Chapter 11. The Sentence. 1. Restitution. Numbers 5, 6, and 7. Exodus 21:12, 22-27, 22, 1-15, Leviticus 24, 18-21. 2. Death penalty. Genesis 9:6, Exodus 21:12, 14, Leviticus 24:17. 3. Corporal punishment. Deuteronomy 25, 2 and 3. The law system of God's Word has no place for imprisonment except temporary retention pending a trial. If found guilty, the man could be subjected to 3 kinds of sentences. First, in minor offences, there could be a sentence of corporal punishment, a public beating before the court and the people, Deuteronomy 25, 1-3. No more than 40 stripes could be administered, lest, quote, thy brother should seem vile to thee, end quote. Punishment, not abject degradation, was in mind. Second, in most cases, restitution was required, that is, a restoration of what was taken or its equivalent, plus an additional amount. The additional amounts could be up to 5-fold, depending on the nature of the offence. In Exodus 22, we see that the restitution had to be, in most cases, the equivalent of double the value. However, oxen were valuable for their trained status as beasts of burden, pulling wagons, ploughs, etc., and they were also valued for their hide and meat. The restitution price was, quote, 5 oxen for an ox, end quote, whereas sheep were, quote, 4 sheep for a sheep, end quote, Exodus 22:1. Sheep had a high value as food, as a source of wool, and because of their reproductive potential. Most offences required restitution in kind or an equivalent value. Third, the death penalty was a form of restitution. It did not exclude the necessity for restitution where this was necessary, but in all cases where required, the death penalty was mandatory. Fourth, if an offender, when convicted, could not make restitution, he could then be sentenced to bond service for a time in order to work out his restitution. Texts that speak of this include Exodus 21, 2-6, Deuteronomy 24, 14 following, and 15, 12-15. These texts indicate that the bondservant could be sold to someone who needed his labour when the man who won that judgment needed an immediate recompense. In any event, the bondservant had to be treated as a brother, not as a slave. The maximum term of bondservant was 6 years. Neither debt nor involuntary servitude could go beyond the Sabbath year of rest in the Lord. The premise of these laws is restitution towards a restoration of godly order. All God's laws are aspects of the creation mandate of Genesis 1, 26-28, the establishment of God's order by, first, obedience to his laws of righteousness or justice, and second, by extending the boundaries of God's rule over evildoers and thereby making them serve his kingdom. Ungodly sentences penalize the law-abiding by requiring them to maintain in prisons at great cost all criminals who are convicted. A professional criminal class is developed so that the godly are required to support the ungodly and see them increase. Fifth, in Deuteronomy 21, 18-21, a law long part of American law, the habitual criminal was executed. A permanent criminal class was thereby avoided. For at least the first half of the 20th century in most American states, a criminal, either on his 3rd or 4th conviction, depending on the state, was ruled to be an habitual criminal and sentenced to death. Humanism in the courts has overturned this premise and led to the creation of a growing criminal class. Sympathy for criminals has led to an indifference in many quarters to the plight of victims. Law cannot be neutral. It condemns some and protects others. The issue is, whom does the law protect, and who gets disfavour from the law? The law can protect the state, the lawbreaker, or the law-abiding peoples who are victimised. It is clearly apparent that, in the latter part of the 20th century, the law has been protecting the state above the people. At the same time, the decisions of the US Supreme Court have demonstrated an arrogant unconcern for the people and have favoured the criminal to an increasing degree. The sentence of the court is, were godly, the first line of defence of a people. Occasionally, sometimes frequently, there are wars between nations, sometimes over trifling political reasons, sometimes to forestall aggression and invasion. These are normally occasional, although still too frequent and costly. There is, however, a constant around-the-clock warfare by the lawless in a society against the law-abiding. In this warfare, the police are relatively helpless because the courts and their sentences constitute the primary line of defence. This perpetual war of the lawless against society is lost when the sympathies of the courts and juries are with the lawless. Because the present legal system permits it, Christians are commonly excluded from juries. One lawyer, not a Christian, observed, quote, "The only way now that you can get a jury of your peers is to be a Skid Row character." End quote. Increasingly, good men and women ask to be excluded from jury duty because they know that after a day of waiting, they will not be picked. Some have commented that if they had the money, they would challenge the premises of exclusion whereby professional men, businessmen, the clergy and others of moral stature are routinely excluded. The background of the jury system is related to the nature of witnesses, that is, judgment in its broader sense coming from the community of God's people. At one time in US history, no man could be a witness unless he could take an oath religiously as a Christian. Some judges would allow an unbeliever to testify without an oath, but they would then warn the jury that the man's word was not worth much since there was no fear of God in him. Now there is no fear of God even in churchmen when under oath. There is thus a rottenness in the bones of the legal system.